Osking?
May it please the court, Joseph Hoffman for Michelle Osking, the appellant. I would like to reserve 3 minutes for rebuttal.
2 minutes? Very good. Thank you.
By way of background about this case, this is a supplemental petition to modify child support and alimony. It was filed in December of 2009. It was finally completed in December of 2012. There was substantial documents involved in this case, so counsel and I agreed with the judge that at the trial there wasn't really a lot of testimony except for one accountant. At the trial we spent all our time simply marking exhibits, and then the arrangement was that the court, that each of us would submit memoranda, and then the court would rule. So that's basically the background of this case, Your Honor. This is a very narrow appeal dealing with page 7 of the final judgment, which is a child support guideline worksheet. What happened was that over these 3-year period, the determination had to be made, what is the new child support guideline that Mr. Osking were to pay. So the judge, in his letter ruling to us, indicated that the best indication of Mr. Osking's income was his income tax return. His income tax return worked out was that his average monthly income was $238. Now, the child support guideline is attached, so page 7. So what happened is $238 was put in, and then Ms. Osking's money as gross. In addition to that, Your Honor, the alimony was also put in there. Even though it wasn't being paid, it was put in as a subtraction from Mr. Osking and an addition to Ms. Osking. So we ended up having, on the guideline worksheet, Mr. Osking's income a minus $634. This resulted in, and just to add something here, Ms. Osking has the children 78% of the time. So by virtue of this calculation, the guideline worksheet indicated that Ms. Osking was to pay him $848 per month for the year of 2010.
Let me ask you a question about the calculations on guideline worksheets, score sheets, or worksheets, score sheets in the criminal division. Let's assume, and I don't want to talk about these numbers because these numbers are a little different, but let's assume you've got an income, the court makes a finding that he's got an income of $2,000 a month, and the court's going to award $500 a month alimony. On the guideline score sheet or worksheet, the child support worksheet, is it the practice to go ahead and subtract the $500 from the $2,000 for the net income to be used to score?
Yes.
So the scoring, the taking of the $900 was not an error there. It's just that the starting number of 231 was the error.
Well, that's true, because we recaptured, the court denied the modification of alimony, and we have recaptured that in an arrearage. Actually, the court said alimony is abated for 1 year, but
so you're not complaining as to the method of the calculation, that is the deduction of the alimony.
I am not, Your Honor.
Strictly the dollar amount he started with.
Yes, Your Honor.
Okay.
Because we're recapturing that, he's going to have to pay it anyway.
Okay.
So the child support worked out. It was $634 minus, and this resulted in the $848 a month the former wife was supposed to pay the former husband, which resulted in a credit to the husband of $13,000 and some change. This is what we're appealing. Now, there's basically two arguments that we have, and I guess I want to go first to the Tomaseski case, because we've got a discussion as to how do we impute income, should we impute income, etc. The Tomaseski case, the facts are, I think, I don't have the exact dollars right in front of you, but
Are you asking, did you ask the trial court to impute income?
said
Or
if-
did you ask them to make a different finding as to what his income is based upon the bank records?
Both, Your Honor.
So you alleged either unemployed or underemployed, you alleged capabilities of certain income, you presented some type of evidence as to what the job market is and what his potential would be. Isn't that
No.
what normally happens in an
No,
imputation
we
of
didn't,
income?
we didn't do that, Your Honor. If I could just talk about Tomaseski for a second. Tomaseski is a case where the father had a financial affidavit of $1,000 roughly and expenses of $6,000. And the dispute in Tomaseski was that the court did not properly impute income to the father. The Tomaseski case says, well, this is not really an imputed income case. This is a factual case where you look at his income and his expenses. In this case, Your Honor, we have
Well, why isn't that the same thing? That's what I'm asking. Why isn't that the same thing here? Why are we calling it an imputed income? Why isn't this the same judge? He's got this many expenses he seems to be paying, yet he says he's only got this little amount of income. You need to make a finding that he evidently does have this income.
Yes, Your Honor.
So that's not, I mean, imputed
It's
is
not
something
imputed.
different.
No,
Okay,
that's
okay.
confusing the issue. Now,
Okay, good.
what we have is he submitted several financial affidavits, which I don't want to focus on. In that case, there was an imbalance between income and expenses. The expenses were more, but that's not the issue before the court. There's 5 sources of cash flow that were exhibits that we all marked and we all agree. Here, the 5 cash flows in this gentleman's business is, we introduced, marked as exhibit and introduced into evidence his SunTrust personal account. This is all during 2010. And that indicated deposits of $50,575. He had a PayPal account. That was deposits of $12,498. Then he had a tax return for 2010 Essex Properties. He's the sole shareholder. Those deposits were $9,000. Then he had a tax return for another business, Advanced Building Association, and that's a corporation. And in that, there was $37,000 cash flow. And the 5th one was SunTrust Savings, his personal savings account, and deposits into that account at $14,000. So that the cash flow, some of these are businesses, some of them are
Let me
personal.
ask you this. He did present a CPA. His witness was an
That's
expert
correct.
witness. Did that, and that expert witness said, based upon his review of things, this is what his income was.
Yes.
Did you point out to the trial court any of those sources that you just identified that the CPA failed to consider in his calculation?
All of these documents, all of the citations were included in the memoranda that we submitted. Our arrangement was...
Okay, well, let me just go back.
Okay.
Do it for you. The CPA, as I understand, came in and testified. I reviewed his business transactions, all these different things, and I came up with this figure that we need to supply to IRS to be his income.
That is the sum and substance of what he said, Your Honor.
Okay. Now, you're suggesting that figure is not right because there are all these other numbers. And what I'm asking is, were you able to show the judge that there were some of these accounts or some of these businesses that the CPA did not include in his calculation? Or are we to conclude that he, having reviewed all the same thing that you're wanting the court to look at, came to a number that you disagree with, but the court obviously could rely upon if the CPA said it?
Well, because of the nature of the situation where we marked all these exhibits. Now, the testimony, I will allow Ms. Black to summarize what his testimony was. There was no specificity with regard to the testimony. We didn't cross-examine or anything of that sort. What we did was mark all the exhibits.
Okay, so we got a trial judge who's got all this stuff presented to him. We've got a CPA expert who comes in and says, I've looked at all these things, and this is the conclusion I reached, and the trial judge accepted that conclusion. What basis do we have to say, trial judge, you were wrong to rely upon the expert's testimony that was presented to you?
Because it's an abuse of discretion, because no reasonable person would suggest.
So the CPA was an unreasonable person, and his expertise was to be challenged by what?
By the documents that we
The documents that he said he applied his expertise to.
He did not. At the summary of his testimony was roughly that he's been his accountant for many years, and this is an accurate representation. That's all he said. There was no going into, well, what about this, and this.
Doesn't somebody have a burden to do that? If you want the trial court to see that his testimony is inaccurate, don't you have to give the trial judge something to rely upon to show him that it was inaccurate?
Yes, Your Honor. The burden we had, the arrangement we had, was that we'll mark all these exhibits, very brief testimony, and then we will each submit a memoranda of law which sets out all of these elements, all of the citations. So that was the burden that I believe that we met, because that was the arrangement that the judge said. The judge basically, I don't want to speak to him, but he said the documents are so voluminous, it would take so long for us to go over all this. We're going to do all the exhibits, and then each of you submit a memoranda of law, and all of this was in the memoranda of law. All of this was repeated in the motion for rehearing. So in that sense, that was how the burden was created, and that's what I felt that the burden was satisfied. The court felt otherwise. So based on the Tomasewski calculation, and based on the Kanakaris standard of abuse of discretion, which is that if the judicial action is so arbitrary and fanciful and unreasonable, and if in fact there is cash flow that the court, by the way, the court did say, after reviewing all of the documents, he did say that in his final judgment, and in his letter ruling, I didn't do the final judgment, but he did say, I have reviewed all of these documents, and I conclude that the man's gross income is $238 a month, and that it's an abuse of discretion. That's our theory on this case, is that it's so unreasonable that no reasonable man can adopt the view of the court. Thank you.
Very good. Thank you.
May it please the court, I'm Patricia Black, and I'm here on behalf of the appellee, Eric Osking. Your Honors, the accountant did testify in depth in this case. He described the documents he used. He used bank statements, copies of checks, all banking records, and all records of the business in order to prepare the income tax returns for Mr. Osking. Also, documents were presented to the accountant, Mr. Hall, who had been Mr. Osking's accountant since 1994. Documents were presented to Mr. Hall, asking him, did you use these documents? He explained that Mr. Osking's business was a commission-based business. It's insurance inspections. And that often in the bank accounts, he testified, often in the bank accounts, or in the bank account, if Mr. Osking were unsure of a client, his contract would read, the insurance check would go in full to Mr. Osking's bank account. He would then deduct his commission and forward the remainder to the client. It is our contention that you can't use these banking records to determine income. There's monies that moved internally among the accounts. For instance, in the operating account, first of all, there is a mistake in the addition that Mr. Hoffman presented of the $50,575. It is incorrect because, first of all, December 2009 was used, and inadvertently, I've worked with Mr. Hoffman on numerous occasions, so I do believe it was an inadvertent mistake that May was counted twice. So the total sum of the deposits was $46,140.39. But one must take into consideration that he has a tax savings account. It's a personal account. He deposits money over the years in it for purposes of paying income tax. He transferred $5,000 out of the tax account into his bank account. And Mr. Hoffman has counted that $5,000 twice because he used the tax account number and then he used the number that was in the personal account. So there's internal transfers that weren't accounted for within his calculations. Additionally, the trial court found that over a period of years, Mr. Osking's income was drastically reduced due to no fault of his own. This occurred, one of his businesses, which fell apart because of the market difficulties during those years, he lost 3 homes in foreclosure. 2 in I believe it was 2 in 2009 and 1 in 2010. And he began to create advanced assessments to try to take over the loss of income. Now, when you look at the two, if I may grab some documents, when you look at the income tax returns that were used and prepared by Mr. Hall, when you can see clearly in 2010 on the U.S. individual income tax returns, it reflects that he had S corporation business income of $42,413. What's not been taken into consideration, and the judge did take it into consideration, is he had a $38,274 loss. Now, Knight v. Knight does state that you may use this showing an inability to pay, it was sale of a business property, inability to pay child support, also as a substantial change in circumstances. And we produced tax documentation from 2005 to 2011. It appears the trial court did look at all these. I prepared notebooks for them, very organized, for him to be able to go through. And when you look at the tax records as a whole, not going back all the way to 2005, but you can see in 2009 his income dropped all the way down to $14,000. That's when he lost the 2 houses. He then lost the additional house the next year. And I would contend that to use the bank statements and add them all together, it's impossible to determine the income, as Mr. Hoffman asked you, in that way. The accountant determined what his income was. It was 2010, and that has stood with the federal government. There's been no change to it. Additionally, there was a request to impute income in this case. And even if you use the Tomasowski, which follows the Bromson versus DCF formula, the former wife did not satisfy her burden of showing that Mr. Osking was underemployed, voluntary underemployed, or unemployed. To the contrary, the judge found that he was not, because of the drastic change in income. He still continued. He started a new business. He made every effort to keep afloat. He started a new business. Essex fell apart. He had to replace it with advanced assessments. So there was no finding by the trial court that Mr. Osking was voluntarily unemployed or underemployed. And the second part of that standard is if you're making your best efforts to make an income. And Mr. Osking definitely was. As it shows, the next year his income increased, and then steadily after that his income began to increase as he built a new business. So I believe that properly the judge denied the imputation of income because the former wife couldn't get past the first burden. Therefore, I don't believe that there has been abuse of discretion in this case. One cannot expect to add bank account records, and by the way, the PayPal account was for the business to be able to accept credit cards. One cannot think it is reasonable to determine one's income from bank account records. You're not looking at the whole picture that way. Just like even in the tax returns, even the tax returns in the initial brief, numbers were just taken off of various places in the tax returns. You have to look at the tax returns as a whole too. You can't just leave out the loss and pick a number that you believe should be the number to use for income. Mr. Hall testified to some of this, and I believe the expert was correct. I believe that the judge was correct in failing to not imputing income. The standard was not, the burden was not satisfied, and that we would ask you to affirm the court's ruling that he was within his discretion. A reasonable person would believe that a CPA, a certified accountant that had been working with this man since 1994, did have the ability to determine his income, and that it was reasonable.
Questions? Very good. Thank you.
Thank you, sir. Thank you, Mans.
Just briefly, Your Honor.
Sure.
If you look at the child support guideline worksheet and what are the appropriate deductions, alimony is a proper deduction, Social Security, a tax loss or the sale or loss on a business is not a proper deduction for the purposes of the child support guideline worksheet, which is what we are appealing. So the tax return is not properly used because there's two different standards which apply to you. You can have an income, you can show an income of this, but lastly, Your Honor, there's a burden here too. He has a burden to show that his income has been reduced. I know I have the burden here, but he has a burden, and I don't believe he met the burden. Recall, and there's no dispute as to these accounts. In the SunTrust account, I may have made a mathematical mistake, but at least it's either $46,000 money, cash, came into that personal account. Where did it come from? Never an explanation. The PayPal account is a business account. Okay, so that's $12,000 from business. Then he's got a tax return for another business, which is $9,000. So, and he's got a 2000 tax return, which for a business which was not calculated by the court. The court said personal tax return. Didn't say anything about these two business tax returns. So the court missed that. And that ordinary business income was $37,000, and then the SunTrust saving. These are deposits, Your Honor. These are actual active deposits over the period of 2010. And there's no explanation, no reasonable explanation how these deposits got here if his income was $238 a month. Thank you.
Thank you very much. Thank you both.
May we be excused?
Sure. Okay, next is